Hello friends, and welcome to my YouTube channel. And this is a course in which we are discussing about the salient features of the Indian Constitution. This is lesson number 4 of the course, in which we are going to read about the fundamental rights, directive principle of state policies, and the fundamental duties of the citizen. It is presented by me. My name is Rohan Kumar Singh. If you like this video, do hit the like button, and if you want to get more such videos on different educational topics, and if you want to get regular notifications of that, please subscribe to my YouTube channel. So the topics which I have covered in my previous lesson is we have read about the concepts of parliamentary sovereignty and judicial supremacy. So we have read these topics in context of Indian Constitution, as well as we have compared this thing with the constitution of other countries, and we have also read about the concept of integrated and independent judiciary, and we have read about the provisions which are mentioned in the constitution for independent functioning of judicial system in India. So the first topic of this video is fundamental rights. Fundamental rights are mentioned in part 3 of the Indian Constitution, and they are elaborately mentioned from article 14 to article 32. So article 14 to article 18, it deals with the right to equality. Article 19 to 22, it deals with the right to freedom. Article 23 to article 24, it deals with the right against exploitation. From article 25 to 28, it deals with the right to freedom of religion. And article 29 and 30, it deals with the cultural and educational rights. Now, talking about article 32, which is the most important article of all these articles, and it gives the right to the citizen to get the fundamental rights, and it is known as the right to constitutional remedies. Very important. Now, fundamental rights, they are meant for promoting political democracy, and they are also a kind of limitation on the dictatorship of executive and legislature to protect the citizens, to protect the people from the fancies and whims of the executive and legislature. Fundamental rights are there in the constitution, and they are also enforceable by the courts upon their violation by virtue of article 32 and 226. So these two articles gives power to the Supreme Court of India and the High Courts of the states in India respectively for enforcing the fundamental rights. An aggrieved person can directly go to the Supreme Court for the violation of in the case of violation of fundamental rights and for its enforcement. So it is very important that a person can directly go to the Supreme Court. Otherwise, in any other case, he has to appeal in the lower court first, then the appeal goes to the High Court, then to the Supreme Court. But in the case of violation of fundamental rights, he or she can directly go to the Supreme Court for its enforcement. And Supreme Court can issue certain writs, and these writs can also be issued by High Court, okay, for enforcing the fundamental rights. So the first is the habeas corpus, second is mandamus, third is prohibition, fourth is certiorari, and fifth is quo warranto. So these 5 rights issued by the courts for the enforcement of fundamental rights. Now, apart from the Supreme Court and High Courts of India, Parliament is empowered to give these powers that for issuing writs to any other courts also. So they have to frame a law, and accordingly these powers can be given to any other courts also. But right now these powers are with the Supreme Court of India and the High Courts of states in India. Fundamental rights are not absolute and subject to reasonable restrictions. So there are certain conditions to the fundamental rights for exercising these rights. They are not absolute in India. Why? Because we have to balance the democracy with the security and integrity of our country. So there are certain instances which are happening, and which are happened in the past also, and they are going to be happen in future also, which causes unnecessary use of fundamental right, or I can say a wrong use of fundamental rights, which can impose security situations to our country, and it also harms the secular integrity of our country. So that's why they are not absolute and they are subject to reasonable restrictions to create a balance. And they can be curtailed or repealed by the parliament through a constitutional amendment act. So it is also very important that as fundamental rights are not absolute, they can be curtailed or repealed by the parliament only, okay, through a constitutional amendment act. By bringing an amendment to the constitution, article 368 has to be invoked, okay. And they are also suspended during national emergency. So it is also very important, whenever a national emergency is there in the country, the fundamental rights gets automatically suspended except article 20 and 21. So these two fundamental rights remains in force, otherwise all other rights are their enforcement are suspended, okay. Now we'll talk about directive principle of state policy. So we have fundamental rights for creating a kind of political democracy in India, and to ensure the social and economic democracies, social and economic welfare of the people, directive principle of state policy are there. So these are the directives. The name itself suggests that these are the directives which are given by the constitution to the state for the welfareism of the people, okay. And these are the novel features of the Indian constitution which are mentioned in part 4 of the constitution. And they seek to establish welfare state in India which is meant for the welfareism of the people. Now directive principles, they can be classified into 3 types. The first is the socialistic principles. Second is the Gandhian principles, which are based on the ideology and guidance of the father of our nation, Mr. Gandhiji. And the third is the liberal intellectual type of directive principles. They are not enforceable by courts upon their violations. So they are not enforceable by courts. Unlike the fundamental rights which are enforceable by courts, directive principles are not enforceable by courts because there are certain conditions which are necessary to fulfill these directive principles. To ensure economic democracy, we have to ensure that the state is well economically developed enough to promote such economic democracies to the last citizen of our country, okay. So these are not enforceable by the courts. There are certain conditions to it, and it shall be the duty of the states to apply this principle in making laws. So any kind of law which is passed in the parliament or in the state legislative assembly, any kind of schemes made by the union government or the state government which is related to the welfareism of the people, they are inspired, they are derived from the directive principle of state policy, okay. And they imposes moral obligation on the state authority for their application. So that's why directive principles are included in the Constitution of India, because it imposes a certain obligation on the state authority so that they can take those ideas in making laws, in making schemes for the welfareism of the people of the country. Fundamental duties. So originally fundamental duties are not there in the constitution during its adoption. They are included by 42nd Constitutional Amendment Act of 1976 during when an internal emergency was there in the country in 1975-1977. And these duties are added on the recommendation of Swarna Singh committee. So a committee was formed which recommended for including fundamental rights in the constitution itself. Now, one more duty was added with 86th Constitutional Amendment Act. So kindly tell me in the comment section which duty was added by the 86th Constitutional Amendment Act, okay. Now part 4a, in part 4a there is article 51a which mentions the fundamental duties, and some of the duties I am going to read here. First is to respect the constitution, national flag and national anthem. Second is to protect the sovereignty, unity and integrity of the country. To promote the spirit of common brotherhood amongst all people, and to preserve the rich heritage of our country and culture. So these are some of the fundamental duties, okay, and they are not justiciable. Kindly remember this. They are not justiciable unless or until there is a law framed by a statutory authority. Okay, unless or until there is a law, they are not justiciable. For example, there is a law which mandates to respect the constitutional national flag and national anthem. It means we cannot insult our national flag and national anthem. Okay, and that's why they are justiciable. There is a law, that is the Insult to the National Honor Act, which penalizes for insulting the national flag, national anthem, or the constitution. Otherwise, they are not justiciable in nature. So thank you very much guys for watching this video. If you like this video, do hit the like button, and if you want to get various videos on different educational topics, you can also subscribe to my YouTube channel. And if you have any kind of doubts, any kind of suggestion which you want to share with me regarding any videos made by me or this particular video, please post it in the comments section below and I will reply to you. It's my guarantee. Thank you very much for watching and have an awesome day ahead.